we go. Here we go. Who we gonna have up first? I don't know.
Officer
It's a
Pearson,
total
are you with
surprise.
us?
You need him?
Yeah, I'm still here. I'm still trying to figure out the camera.
The
That's all
camera.
right. We're gonna no, you can have a seat, Mr. Ortiz.
All right, Mr. Ortiz, have a
You're all
seat.
set. Oh no, we don't need the CO. You're good.
Okay.
Sorry, never mind. You're all good. Thank you. Yeah, if you can't figure out the camera, we'll move forward without it for today.
Okay, thank you.
We gotta keep it going, okay? So yeah, so we're gonna get started then. So good morning. I'm Parole Officer Chisel. I'm hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Luis Ortiz, inmate number 343293. Today is Monday, April 6, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Carl Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Luis Ortiz, 343293.
Did he get his tattoo headed? I mean, his tattoo
is available via video live stream. Present this morning is your attorney. Can you please identify yourself?
Sure. Attorney Alfonso Sirico with the Parole Revocation Unit on behalf of Mr. Ortiz.
Thank you. And also present is your charging officer. Can you please identify yourself for the record?
I'm covering PO Clive Pearson, covering for.
What up, Em?
Can I just explain to my client?
Sure.
So, Mr. Ortiz, your
hairline. That's what I was trying to say.
Grant, correct?
I believe so, yes.
Okay, just I'm not sure what you heard or not heard. P.O. Pearson is covering for her. So I don't want you to think I know he wasn't your supervising officer. He's just covering for a colleague, okay? Just want to make sure you're clear on that.
Yes, sir.
Okay.
Thank you. So this is the preliminary hearing, which has three purposes under Connecticut law. The first is to determine if there's probable cause that we committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. But do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Ortiz and Officer Pearson, can you both please raise your right hands? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth.
What up, Tish?
And nothing but the truth, so help you God upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for today. So first I'm going to read your rights. Then we'll review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And then after the state's opportunity, you will have the same opportunity. At the conclusion of this hearing, I'll inform you.
What up, Hector?
Which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Right. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yeah. Yes.
So we'll now review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So Officer Pearson, can you please review the charges for us, starting with charge number 1 under OBL laws, the condition of legal obligation?
Yes, on March 5th, 2026, at approximately 6:50 a.m. at the Connection Halfway House, you engaged in a verbal altercation with another offender regarding the scheduled breakfast time of 7 a.m. You asked the offender, who cooks the meals for the entire house, if you could have breakfast earlier than the scheduled time. After the offender denied your request, you responded in a hostile and aggressive manner by telling him to suck my dick.
What?
The residential aide asked the two of you if everything was okay. You stated, he's just being a bitch. The offender replied, how about you come do something then? You immediately walked up to him in an aggressive manner, positioned yourself directly in front of him with your fist clenched and said, nigga, I'll break your face. Your posture and proximity to him and clenched fists created a clear and immediate threat of physical violence. The RA physically positioned himself between the two of you and told you to calm down. The RA asked you why you were downstairs. You reported you asked staff if you could take your medication, which staff permitted you to do so. As you walked into the office, you continued to be aggressive and verbally assaultive, calling him a fucking bitch.
Damn,
when the
son,
offender
where'd you
said,
find
"So
this?"
do something," you again advanced towards him with your fist clenched while saying, "What's up, nigga?"
I knew this was going to
Your
be a good
actions
one.
demonstrated continued aggressive posturing, which staff believed you were preparing to physically assault the offender. Due to your actions, the RA intervened again by stepping between the two of you again and directing you to go into the office to take your medication. After taking your medication, you were instructed to go to your room to de-escalate the situation.
Nah, this is not
Your
real.
aggressive behaviors were consistent with Connecticut General Statutes 53A-62, threatening in the second degree by intentionally place or attempt to place another person in fear of immediate serious physical injury through physical threat. You violated your conditions of parole, specifically obey all laws. I will obey all laws to the best of my ability.
Hey, he's not doing a good job at
Charge
that.
And charge
two.
number, yeah, sorry, thank you.
Charge 2, halfway house placement. On March 5th, 2026, at approximately 6:50 a.m. at the Connection House halfway house, you engaged in a verbal altercation with another offender regarding the scheduled breakfast time of 7 a.m.
But
You
wait,
asked the
there's
offender
more.
who cooks the meals for the entire house if you could take your breakfast earlier than the scheduled time.
Deja vu.
The offender denied your request. You responded in a hostile and aggressive manner by telling him to suck my dick. The residential aide asked you
2 days in a
you
row.
if everything was okay. You stated, "Yeah, he's just being a bitch." The offender replied, "How about you come do something then?" You immediately walked up to him in an aggressive manner, positioned yourself directly in front of him with your fist clenched, and said, "Nigga, I'll break your face." The RA physically positioned himself between the two of you and told you to calm down. The RA asked why you were downstairs. You asked staff if you could take your medication, which staff permitted you to do so. As you walked into the office, you continued to be aggressive and verbally assaultive, calling the offender a fucking bitch. When the offender said, "So do something," you again advanced towards him with your fist clenched while saying, "What's up, nigga?" The RA
Hey, what up,
between the two
Steven?
of you again and told you to go in the office and take your medication. After taking your medication, you were instructed to go to your room. Your actions violated the halfway house agreement. Specifically, I will treat others with respect and not engage in verbal or physical altercations with other supervised persons, staff.
Hey, am I having deja vu? Or
The state has also submitted evidence in support of the case. Can you please review the evidence submitted for us?
hey, this is real life right here. People are actually out here wilding like that.
Pearson?
Hey, but it looks like he's taking it. He's taking it
Yes,
well.
please, can you please review it for us?
I'm hoping for an outburst though.
Hold on,
Hopefully he didn't take his medication today.
Pull it up real quick.
See? Huh?
You're a bad boy.
Bad boy, bad boy.
Do you know
What you
how-
gonna do? What you gonna do?
Do you know how you're a bad boy?
Why?
Your name is James, and then last year in school, there's another boy named James.
What are you eating? Are you eating cookies? Oh.
Tu queres uno?
Mm-hmm.
Okay.
What kind of cookies you got?
If you don't have it available, I have it in front of me.
I will ask him.
I have no objection to the hair examiner listing the exhibits.
Yeah. Do you have it, Officer Pearson?
No, I had only printed out the parole violation report, so the evidence is not on that form.
Okay,
But-
okay. so
Hey,
I'll
this
review
isn't
it.
real.
So
This is
please
AI
follow
generated.
the Following exhibits, and they're marked for identification purposes as Exhibit A, the remand's actual custody. Exhibit B, the parole violation report. Exhibit C, the parole conditions. Exhibit D, the halfway house agreement. Exhibit E, the incident report dated 3/5/26. Exhibit F, the decision information summaries. Exhibit G, the release to federal detainer. Exhibit H, the Connecticut General Statute 53A-62, threatening in the second degree. Exhibit I, the video footage of 3/5/26 incident. Exhibit J, the notice of parole violation. And Exhibit K, the notice of parolee rights. So counsel, to confirm you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today.
Yes.
All right, and I did not receive anything from the defense at this time. Do you need time to submit any evidence?
No.
We do not have any witnesses. So at this time, the state will have an opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations. So Officer Pearson, any comments towards the charges or the severity of the allegations?
What up, Shot?
No.
counsel.
I want him to. I want him to
Charge
talk.
Number one, under legal obligations. I'm asking that a no finding be made because I don't believe as charged under legal obligations and meets the elements of that particular charge. The language.
Thank you,
according to
Tiffany.
Legal obligation. The language.
That
of
fool
the
does
rule,
have some
I will, to the
ears.
best of my ability, fulfill all legal obligations, including payment of all applicable child support and alimony orders, and the elements to be charged under legal obligations.
What up,
Parolee had a
Alana?
legal obligation, and two, parolee failed to fulfill the legal obligation to the best of his or her ability. I
Lou, thank you.
don't believe as charged, that meets the definition for legal obligations.
This is a job interview for Amazon,
Sorry,
Target,
sorry.
Walmart, but I don't think he's going to be getting the job today, if you will.
Keep going, counsel.
As far as the halfway house placement charge, it's the same set of facts from March 5th of 2026.
What up, always?
Mr. Ortiz, do you recall approximately what time this incident, I know the parole officer that's filling in gave a summary. Do you recall approximately what time in the morning this was when this incident occurred?
This was hangry.
6:50.
Okay.
He couldn't wait 10 minutes?
AM. And where were you going that particular day? Because according to the materials submitted, you had asked to have breakfast earlier. Were you going somewhere on that day?
Yeah, I had an appointment, my last scheduled appointment to rush for my IOP.
Okay. How many days a week were you going to IOP?
I started with 5, then moved to 3, and since she found me deemed that I didn't really need the treatment, she was gonna sign me out on that Friday, if I'm not mistaken. But I asked her to keep me. I asked her to keep me there a couple more days because I was taking my mental health treatment.
Okay, so on March 5th, 2020, you wanted your breakfast earlier because
What up,
you were
Brian?
going to your end
Yes.
of your IOP class. Is that correct?
Yes, yes, sir.
Okay, okay. And at some point, there was some words exchanged between you and, as indicated by there was another. the
Luis
person that
Harvey,
asked
to you.
for breakfast was another offender in the halfway house, correct? It wasn't a staff
Yes, sir.
member? Okay.
No, sir.
And, okay, and some words were exchanged.
Yes.
Okay, at any point in time, did you put your hands on him? We know it's a him.
No.
Okay, at any point in time, did you strike the individual?
No.
Okay, and I did explain to you when I spoke
Intensive
to you
outpatient program?
that a video was submitted by the supervising parole officer, but the video does not have any audio. So I have no idea who said what to who initiated the conversation, and I did explain that to you, correct?
Yes, sir.
Okay. And at some point while this incident occurred, you were scheduled to take your medication, and I believe the staff members at the house did provide you with the medication, and you did take your medication that particular day, correct?
Yes.
What do you
sir.
guys think? He's not like on Zoloft,
And once,
lithium?
I believe one of the RAs or the resident assistant there, once they separated you, there were no more issues after that. Is
Matthew.
that a fair statement?
That's a fair statement. Yes.
Okay.
Not that though.
All right.
Paxil.
As far as part two, the other on the halfway house placement, the other question I would have, I'm not going to actually, P.O. Pearson, were you able to review Exhibit I, which is the video that was submitted by Parole Officer Grant?
No.
Okay. I just want to add, so this question is not going to be directed at P.O. Pearson because he's not the supervising officer, nor did he view the video. Exhibit B, which was submitted on page number 3.
I just got my cookies and milk, so I don't be
I
acting
believe
like
it's the
that dude.
last paragraph of the top of the parole violation report where it indicates my client took his medication, no action was taken. This is PM Arnold provided P.O. Grant with a copy of this video footage. Then it goes on to say, The video footage was reviewed by this PL parole supervisor. I'm assuming that's what PS McBulliu and PS Gibbons. At that time, parole supervisor Billy authorized a remand based on Ortiz's behavior, which visibly agitated, clenched his fist, advanced towards the offender, and direct threat of physical injury. My question would have been, who made the call to the remand? Was it a field parole officer who is supervising my client, or did the supervisor make the call? And also the direct threat of physical injury. I don't know how that was obtained because there's no audio in the video. We're not disputing there were some words exchanged. That's not what I'm saying here, but I have no idea who initiated the conversation, what was said between the two parties. Neither party was arrested. Clearly, my client wasn't arrested, neither was the other person who was involved in the exchange of this word. So if you were to make a finding of probable cause, in my humble opinion, I don't think it rises to the level that is so serious that my client needs to be incarcerated further. As indicated through his testimony, he was going to his IOP. He was scheduled, I believe your appointment was at 8 a.m., if my memory serves me correct.
Yes.
Okay. He had asked for breakfast be provided to him earlier. That was denied. Once again, we're not disputing that this words exchanged. When the staff asked him to take his medication, or my client asked, he did take his medication, so he did comply with that day. It is indicated he was at the tail end of his IOP, which he was attending. I know he's not charged with him not, taking his medication or doing treatment, but I just want to give you a little clarification that he was going to treatment, he was taking his medication. So I am asking that part one, I'm asking that no finding be made straight out. Halfway house placement, I'm asking if you were to make a finding. I said, I'm having a difficult time because the video, there's no sound on it, and it's unfair for us to present a defense because I have no idea who initiated the conversation. Once again, I know my client admitted on the record under oath that words were exchanged, but I have no idea in what context those. If my client actually threatened the other individual, there's no way to tell with a video that has no audio. That's all I have. Thank you.
Any comments, Officer Pearson? Any responses at this time before I take a moment?
Yes. My question would be, how long were you going to the IOP sessions?
Like a month.
A month.
Okay, Louis, before you answer the questions, I'll let you know if I want you to answer them or not, because you're under no obligation to answer any questions except for me.
You should have told him before he answered the first one.
No, that's all right. That's what he just asked us. I'm okay with you answering that question.
So during the time that you were going to the IOP for a month, how many times have you asked to have breakfast early to attend your appointments?
Yeah, Louis, I do not answer that question.
Do not answer that one.
Okay. Well, from what Grant has provided, there was no other time that you asked to have breakfast early for your Rushford appointment. What was the travel time from Rushford to your appointment? Because Rushford is very close to the halfway house, correct?
Louis, do not answer that question.
And then even though that there's no audio, she did write in her report that he clenched his fist, he advanced towards the offender. We don't need audio to tell if that transpired or not. And part of the halfway house agreement states that I will treat others with respect and not engage in verbal or physical altercations with other supervised persons, staff, or third parties. So I think that the findings should stand for the halfway house placement, because you did advance, you did have inappropriate verbal altercation with the offender, and staff had to intervene because there almost broke out into a fight. So I think that she provided enough evidence right there to see that you violated your halfway house agreement. When it comes to the general Connecticut state statutes, she also reported 53A-60 62, which says threatening in the second degree or by intentionally place or attempt to place another person in fear or imminent serious physical injury through a physical threat.
You see, the
I
issues
would
here
say that,
is
both
that
of you
he's on parole, so
engaged in that.
he has to follow the rules of the parole board.
So I think that the finding should stand for that as well.
He's governed by different rules than us.
Thank you,
If you're not on
Officer
parole or
Pearson.
probation,
Counsel?
The only comment I'm gonna make is without audio, I understand what the visual part of it is. I did review the video numerous times. As far as a verbal threat, direct threat, as noted, there's no way to tell what was said and who started the conversation. I don't disagree that my client went towards the other individual went towards my client. We're not disputing that part of it.
Thank you. I am just gonna take a quick moment before I make my findings.
hey, Gigi, you hit the nail on the head right there. People sign off and then they don't know what they're signing up for. Just coming into contact with the police, that's a parole violation in some states. Getting into a verbal altercation. Why'd you do that? In the halfway house, that could have been cause for his violation of probation right there. So, but then it seems like he has some mental health issues.
Today, I've also reviewed all the evidence submitted as well. With that, Mr. Ortiz, I'm going to announce my findings. So on charge number 1, the condition of obedience of the under the condition of obedience of the law with legal obligation, I am going to make a no finding based on the defense's argument today, and where the description does not meet the elements of the condition of legal obligation. As counsel noted, it's the parolees had a legal obligation, and that legal obligation was not fulfilled to the best of their ability. On charge number 2, the condition of halfway house, I am going to make a finding of probable cause based on the evidence submitted in states exhibits B, C, G, and T. With that, I want to acknowledge that
thank you, Kimberly.
Mr. Ortiz has been incarcerated for approximately a month at this point.
But he's definitely getting his breakfast early.
That's sufficient amount of time period for this behavior that occurred. So I'm going to find that the acts are not serious enough to warrant the revocation of your parole. So we will reinstate your parole effective today. The facility will be notified of that. Your officer is aware of it. They will coordinate your release to put you back in the community. Okay.
Thank you.
So that does conclude today's hearing. Does anybody have any questions?
I do not. So Lewis has indicated, I covered with you what the possible scenarios were at this time. There is no second hearing. You'll be back on supervision with the understanding on supervision until 2029. So you need to follow parole officers.
He'll be back.
And the behavior at the halfway house. You understand that?
Yes.
All right. I'll contact Ms. Torres to fill her in. Since you gave me permission to speak to her, I'll give her a call to fill her in.
I had a brief question. They already went and checked my sponsor, so that means, do I still gotta go back to the half house or?
Hey, Colton, thank you.
I can't answer that for you, and I believe P.O. Pearson is just filling in. So you have to speak to your parole officer to figure that out. I don't have an answer for you because that's.
So most likely, I'll
Connecticut.
look into it to see how far they got into calling your sponsor. Do you know if they called your sponsor at all?
Yeah, I believe they went and checked the house and everything.
Okay, so you probably want to get placed right now because you're getting reinstated today, so you're gonna have to get picked up today. So most likely I'll be coming up to the prison to get you and bring you back to the halfway house, and then we'll go from there, getting your placement situated. Okay. Just as a backup, you're sure that they called, right?
The what?
Are you sure that they called your sponsor?
Yeah, I'm kind of positive.
Okay.
When she came, she told me herself, Ms. Grant.
This is
Okay.
Connecticut.
And I'll let
Connecticut prison.
Yeah, do you need anything additional from him right now? Like,
I was going to
anything?
ask for the sponsor's information, but he confirmed that parole already contacted her, so I guess we'll be fine with that.
Okay,
So
all right. So then,
I'll just speak more of
okay.
him when I see him later.
Perfect. All right, so I will send the paperwork over to the facility records now so they can get started on the process. Okay, Mr. Ortiz?
Yeah, thank you. Sir, I appreciate you too.
All right. Good luck to you. Thank you, P.O. Pearson. And Lewis, I'm going to contact Ms. Torres so she knows.
Hey, I'm thinking about getting my hairline tatted.
Preliminary hearing for Luis Ortiz. I mean, number
You-
3,
should I tat my
Mr. Ortiz.
should I tat
Thank
my
you.
hairline? Ay, ay, ay. He probably got that done in prison. That was wild, man. Hey, what up, Teresa? How's it going? Yeah. All right, up next on The Price is Wrong. What do you guys think this guy did to end up in prison? What kind of violation did Healthy Boy do right
Listen,
here?
I have to find her. Here she is. Found her. We're gonna get started, okay?
Okay.
I can't afford to go to Turkey. Nah, I gotta get it tatted.
Good morning.
Yeah, he's getting out.
So
Yeah,
good morning, I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Andre Brinson, inmate number 258644. Actually, can I take a quick moment? I just realized I didn't send an email I needed to send for the person from you. Sorry, Mr. Brinson. I just realized I have to send an email for the gentleman before you, and I didn't do it. So I'm just
Okay.
gonna send a quick email and then we'll get started. I'm sorry.
Yes, ma'am.
take your time, parole board hearing. Anyhow, hey, so right now I'll go ahead and take this moment since they're not talking. So today, for those of you that have been following my progress on the surgeries and procedures that I've been having, I had my last procedure done today. I went ahead and they removed the last what was it, stint that I had on my pancreas. Before I went into that procedure, the doctor came to speak with me, and I had asked him, I was like, hey, do you know what caused that blood clot that I had on my colon that led up to me having half of my colon removed back in December? And he was telling me that when they perforated that area around my pancreas, that I ended up having like pancreatitis, and that ended up causing the blood clot. And man, that caused a whole bunch of other issues. So I ended up having the last stint removed today. I just got home from the hospital maybe about 2 hours ago, so I'm still a little bit loopy. They had me on that propofol. If you guys ever been under
Sorry again. Good morning. I'm Parole Officer Trisell, and I'm hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Andre Brinson, inmate number 258644. Today is Monday, April 6, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Robinson Correctional Institution. Can you please state your full name and DOC?
Hey, David, Louis Harvey, if you will.
Darrell Brinson, 258644.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, Deanna Jean on behalf of Mr. Brinson.
Damn, Tracy.
So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is a better weightier evidence must establish that, more probably than not, the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate parole, which means releasing and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Brinson, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for today. So first I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, ma'am.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. You understand these rights, and are you ready to go forward?
Yes, ma'am.
Hey, I love
The
little
charges that
Debbie's.
the state, your parole officer is bringing against you, and the information underlying each charge. Before we start, I do want to note on the record that a no finding was made at the preliminary hearing for charge number 1, the condition of program participation. And a no finding was also made for the allegations against Mr. Brinson for charge number 2, the condition of no consumption of alcoholic beverages, where he was charged with purchasing or possessing alcohol.
Hey, Big Mike,
Therefore,
thank you.
those charges are not going to be taken into consideration for today's hearing. So we're going to start on charge number 2, the condition of no consumption of alcoholic beverages. On 1/29/2026, you wrote and signed a statement indicating you purchased alcohol. Not going to consider that one, sorry. I didn't do this well. On 1/13, just grab the other one. On 1/13/2026, you disclosed to the connection maintenance eye detector exam that you had bought and consumed alcohol. You reported that you had purchased alcohol 2 or 3 times. In addition, you admitted that you consumed alcohol 1 time at the beginning of 2025. So that's the part counsel, sorry, was going to be taken into consideration. The consuming alcohol the 1 time at the
The lie
beginning of
detector test
2025.
determined
Okay.
That's the only
That
one
was
to
a
get
lie.
it.
Okay. So now charge number 3, the no contact with minors. The charging officer reported that on 1/29/26, you wrote and signed a statement indicating that you have been alone with a minor related male on multiple occasions. You also admitted that you had been in a residence where minor children reside. On 1/13/2026, you disclosed to the connection maintenance eye detector examiner that you had unapproved contact with a minor. You admitted to having transported a related 14-year-old male in your private vehicle on multiple occasions alone. On
Oh, that's no good.
1/13/2026, you disclosed to the connection maintenance eye detector examiner that you had visited a residence of a friend where a 10-year-old child resides. You're aware that the minor child resides there prior to you going to the residence.
Oh, we got a
The
PDFer.
condition of problem sexual behavior treatment. The charging officer reported that the CTPSB treatment agreement prohibits you from using or possessing alcoholic beverages. You're in possession of alcohol as evidenced by the photo in your cell phone of you holding vodka dated 11/27/25. The CTPSB treatment agreement restricts you from the locations frequented by minors. You violated this condition as followed. On 6/21/25 at approximately 3:26 p.m., you were at Spare Time Entertainment, a location frequented by minors, where you are restricted from visiting. On 6/27/25 at approximately 8:23 p.m., you are in the presence of minors at a social gathering. You are restricted from having contact with minors and or being in locations where minors gather. On 11/15/25 at approximately 7:21 p.m., you are in the presence of minors at a social gathering. You are restricted from having contact with minors and or being in a location where minors gather. On 1/13/2026, you disclosed to the connection maintenance eye detector examiner that you had unapproved contact with a minor. You admitted to having transported a related 14-year-old male in your private vehicle on multiple occasions alone. On 1/13/26, you disclosed to the connection maintenance eye detector examiner that you had visited a residence of a friend where a 10-year-old child resides. You are aware the minor child resides there prior to you going to the residence. On 1/29/26, you wrote and signed a statement indicating that you had been alone with a minor related male on multiple occasions. You also admitted that you have been in a residence where minor children reside. You were unsuccessfully discharged from
Connecticut.
CTPSB treatment for problem sexual behavior.
His daughter?
By the state
Oh.
was already identified at the preliminary hearing, and that all remains the same. I did receive exhibits from the defense. I have exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Exhibit 2, the support letter from Newman Davis. Exhibit 3, the support letter from
Nevaeh.
Jacqueline Quinn. And exhibit 4, the letter of support letter from Kay Thompson. Counsel, do you need any time to submit any other documents?
We do not.
And I do not have any witnesses scheduled for this time, so it is now the defense's opportunity to call any witnesses, present evidence, and speak to any of the evidence.
Connecticut, that's right.
Yes, thank you very much. I would just argue concerning the charges 3 and 4, no contact with minors and the CTPSB treatment, that at no point did my client fail to participate in treatment. He, by my understanding, was actively engaged in all the required sessions.
What up, Lori?
His treatment was only discharged after the decision was made to remand him to custody. But it appears from Exhibit I that the connection was still willing to work with him and that he was just given a verbal warning for these allegations. Concerning the allegations from 6/27 and 11/15, the instances of him being at social gatherings. I would note nowhere in those videos is my client seen. My understanding is that some of these videos were sent to him by older family members who felt badly that he had to leave the event because minors were going to be showing
Felt
up.
badly.
But nothing in the evidence, to my knowledge, shows that these videos were, originating necessarily from his cell phone, or whether or not they were sent to him. And Mr. Brinson, just
CO20s,
to
you
ask
say?
you a quick question as to the allegations concerning these family parties. You had mentioned to me when we spoke that you kind of had a personal protocol where if you found out that someone was coming, can you explain that to the hearing examiner, sort of what you would do if you got information that minors were coming?
Yeah, yes, ma'am. My family understood my conditions of parole, that I couldn't be around minors. So I was to leave before the minors was to come. And they felt bad about me not being able to be a part of the functions that they were having. So they would send me videos, and just to like uplift my spirits and make me feel connected still. And concerning me going to a residence where I knew the 10-year-old minor lived, the 10-year-old minor, who is my fiance's son, was never present when I did visit the residence. He was with his dad. So I never went to the house when he was there.
Thank you very much. And then, Mr. Brinson, I just had a couple other quick questions concerning the allegation about contact with your 14-year-old nephew. At the time when you did have contact with your nephew, did you have any indication as to his actual age?
No, ma'am. My nephew, I just got back in contact with my family, and my nephew is a big guy. He's a big guy, and I didn't understand how old he was until I had a conversation with him, and he told me that he was only 14. It was my understanding, I thought he was about 19 or 20 years old because of the basketball league that he plays in and how tall he is.
No way,
and
no
he
way.
has facial hair and everything, and I didn't know that he was a minor. So once I did realize that he was a minor, I had to make it like known to my aunt that I couldn't, like she couldn't ask me to take Pooh Bear anywhere because I was, under parole supervision. And
You're a pedophiler?
Thank you very much. So I would just note this wasn't a situation where Mr. Brinson was trying to deceive parole or conceal these situations. My understanding is that he was forthcoming and brought this to the attention of his treatment provider, and then also disclosed this himself to his PO. And I would add the
He did, señorita.
his background and history. Thank you. Thank you.
Like, how are you not gonna know the age of your nephew? Like, that makes no sense. Regardless of how much time you've been in prison, if you keep connections with your family, like, no way. I call BS on that one. I can't believe it. The lie detector determined that was a lie.
The test determined.
Right, so I listened to the testimony today. I've also reviewed all of the evidence cited. My findings, Mr. Brinson. So on charge number 2, I am going to find that you violated the condition of no alcohol consumption based on the evidence submitted in States Exhibits C, D, and I. On charge number 3, I'm also finding that you violated the condition of no contact with minors based on the evidence submitted in States Exhibits C, D, F, and I. I'll say on charge number 4, the condition of problem sexual behavior treatment. I'm also finding you violated that condition based on the evidence presented in States Exhibits C, C, F, and I. So it does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you will have an opportunity to speak your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I recommend. So, counsel?
Yes, thank you. My client, Mr. Brinson's 45 years old, born in Hartford, raised in Mississippi before returning back to Hartford when he was a teenager. My client does have a very strong system of support in the community, including his brother, his great aunt, and his fiancee, Ms. Thompson. My client unfortunately did lose his father in September of this year after a battle with cancer. My client also does have 4 children between the ages of 9 and 26. Upon release to special parole, my client successfully completed Steinhouse in Hartford. He then successfully completed the Chrysalis Center Transitional Housing Program, and ever since has been self-sponsored at an address in Hartford. While at Steinhouse, my client engaged with the Capital Workforce Partners Best Chance Program and was able to get a number of certificates, including his OSHA 10, flagging, forklift, and scaffolding certifications. My client was participating in physical therapy. He did unfortunately suffer an injury and has been needing physical therapy to reintegrate back into the workforce. So he was all set to start that. Prior to his remand, my client also has experience working. He started his own company, Black Diamond Publishing. He has a business account, book identification number. He has published 9 books and employs a couple different people, including a graphic designer and editor. And that is his passion. I know he's very anxious to get back to that. He also has experience working at FHI out of Basutos. That is the position he was in where he was injured on the job. In November of 2025, my client successfully completed relapse prevention through CRT. He was actively participating in the CTPSB program. He also reports working with community partners in action for basic assistance and housing help. He reports doing the Brotherhood Initiative as well, which is a community-based support program out of Hartford. He reports having to get cortisone shots in his back due to and radio frequency ablation of his spine due to prior injuries.
Too bad he doesn't get them in his eyeballs.
Contact schedule and was compliant with the registry. He was working with NACA for a first-time home buyer program and was also looking and working with the SBA to require a business loan. Since being remanded, my client's been writing an article each month for Jaws of Clay. He's gotten no DRs during this period of incarceration. Upon getting back on special parole, my client's open to returning to his individual residence.
He's a PDFer.
Paying his rent since he's been incarcerated. So I know he is really hoping to return there. As a backup, he would be open to a halfway house if needed in Hartford. After completing physical therapy, my client is hoping to reintegrate back into the workforce. He's interested in either a warehouse or flagging position using those certifications he earned. He's also very anxious to get back to his publishing company, Black Diamond Publishing, and he's open to any sort of recommendations for treatment, including doing CTPSB.
Hey, how about castration?
I'm asking that you would consider referring my client on the next board review date. He has been out for about a year and had been doing well in this period of supervision. He was heavily engaged in treatment and was forthcoming with his providers concerning everything that was going on. Mr. Brinson, is there anything I left out that you would like to say concerning your background and history or any of the good things you were doing at this point?
The good things.
No, ma'am, you covered everything. Thank you.
Thank you very much.
Thank you. I'll just take a moment. Patient.
Hey, you know what? Hey, if I had a family member like this, there's no way in hell I would let him around anybody.
Testimony today, I've reviewed all the evidence submitted. I'm going to just note on the record that Mr. Brinson, this is your 3rd violation on special parole. It is a technical violation. However, the 2 prior ones were criminal violations.
Anybody that forces themselves on anybody
prior to this remand and the
no go
violation court does the NA under the misconduct, graduated intervention and sanction recommendations, but not. And I do just want to put on the record that Polk Community Services has requested a 1-year sanction based on you violating your conditions for approximately a year while in the community. So with that, Mr. Brinson, I'm going to recommend that your parole be revoked and that you serve an approximate 8-month period of confinement as a sanction. That's what the reparole date is, September 30th, 2026. I'm going to recommend the following conditions: no consumption of alcoholic beverages, no contact with victim SW, and no contact with minors, problem sexual behavior treatment, and restriction on pornography. And I'll just do a half the house placement just in case, but I'm going to note that he has his apartment. So what happens next, Mr. Brinson, is that my recommendation is going to go to the board on the 16th of April. What the board can do is 3 things. They can lessen my recommendation if they choose to do so. They can adopt it if they choose to do so. And if for any reason they would want to see a longer period of time as a sanction, they'll ask you to come back for a 3rd hearing to address their questions and concerns before anything longer is proposed. So that doesn't include ways.
So, Mr. Brinson, I'll set up a call with you for the 16th so I can update you on what the board decides. And I had spoken to Kitty this morning, and she, I think, is going to call if she has any questions.
Okay, thank you.
Thank you very much.
This concludes the revocation for Brinson and for 25864.
So you said September 30th, Miss?
Yes, that's my recommendation, but wait until the board decides.
Okay.
He's getting on in September,
All right.
unfortunately.
All right, have a good day.
All right, guys. So I'm gonna take a break, but if you guys want to continue watching, I'm gonna leave the stream up running. If you guys want to jump on over to my YT, it's the same name as on here on TikTok. The name of my channel is at Collect Call From. The little circle, with the A, at Collect Call From, or you could just type in Collect Call From. You guys will see the live running. I think this live is this live is from today. It's from earlier on in the morning. And it runs, I think it runs for maybe like another like 2.5 hours or so. So if you guys want to jump on over, you guys are more than welcome. If you haven't done so, please do so. Hit that follow button. It's free. Doesn't cost anything. I don't ask for any gifts, but I do ask for tapping the screen, dropping comments, and anything that's free. Shoot it this way. Don't be a Scrooge McDuck. Don't be a Mr. Krabby Patty. All of that, I appreciate that, if you will. I try to do these streams from time to time, normally like every day or every other day, depending on what my schedule is right now. Today, I just got home from this procedure. I want to go ahead and take it down and relax a little bit, if you will. Anyhow, hey, for those of you that don't know who I am, I'm James, or Collect Call James, and I'm the host with the most right here at Collect Call From. We do a little bit of parole hearings. We do phone calls with prisoners. We do live court hearings. We do a little bit of this, a little bit of that, and sprinkle me in between, if you will. Anyhow, like I say, if you guys want to go ahead and continue watching, jump on over to at Collect Call From on YT. And if you're wondering what YT is, that YouTube, if you will. Anyhow, hey, I am Collect Call James. You guys are watching. You have a Collect Call From. And like I said around here, life's like a candle. Once you blow it out, it's lights out. And with that, the show will continue, but on another platform. All right, I'm going to speed this up right here and get on to the next hearing. All right, so it looks like they took a little long break, if you will. So here we go. I'm going to go ahead and turn on my camera here. I don't know what this guy did, but I definitely don't like those glasses he's wearing. Definitely suspect around these parts. If you're ever out in Connecticut, proceed with caution, especially with individuals with glasses like this. I'm not sure if he did a crime like that, but I'm always wary of people with glasses like that.
Okay, we're gonna get started, okay? Mr. Rivera Garcia?
Yes, ma'am.
All right, so good morning. I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Juan Rivera Garcia, inmate number 415234. Today is Monday, April 6, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Cheshire Correctional Institution. Can you please state your full name and DOC inmate number for the record?
415234.
And your full name, please?
Juan Rivera Garcia.
Thank you. So this is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Rivera Garcia.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better weight of your evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Rivera Garcia, can you please raise your right hand? Can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, so you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence against you before the hearing. You have the right to submit evidence in support of your case. You have the right to call and examine involuntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Thank you. So we're now going to review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So on charge number 1, the condition of reporting, the charging officer reported that on 9/25/24, you reported to your parole officer, at which time you were instructed to report again on 10/9/24 at the Waterbury District Parole Office. On 10/9/24, you failed to report and did not contact your parole officer. Your parole officer attempted to contact you, and the call went straight to voicemail. Charge number 2, the condition of absconder, the charging officer reported that on 9/25/24, you reported to your parole officer, at which time you were instructed to report again on 10/9/24 at the Waterbury District Parole Office. On 10/9/24, you failed to report and did not contact your parole officer. Your parole officer attempted to contact you, and the call went straight to voicemail. You have not been located at your parole-approved residence located at 278 West Main Street, Waterbury, Connecticut. Your whereabouts in the community remain unknown. Charge number 3, the condition of drugs. The charging officer reported that on 9/12/24, you tested positive for cocaine and signed a voluntary admission form admitting to using cocaine on 9/9/24. On 9/17/24, you tested positive for cocaine and signed a voluntary admission form admitting to using cocaine on 9/15/24. Charge number 4, the condition of travel. The charging officer reported that on 12/10/25, you were arrested in Puerto Rico. You did not have permission to leave the state of Connecticut. On charge number 5, the condition of behavioral management program, the charging officer reported that the offender was instructed to participate in domestic violence program and was aware of the instruction. The offender failed to participate in the program as instructed. The offender was referred to domestic violence program on 1/8/24, on 2/8/24, 3/21/24, 5/2/24, and 6/27/24. The offender was instructed to attend domestic violence group sessions, but failed to do so and was marked as an unexcused absence. Did the offender accumulating 4 unexcused absences, he was unsuccessfully discharged from the program on 6/27/24. The offender was referred to the domestic violence program again on 7/16/24. On 9/9/24, 10/7/24, and 10/14/24, the offender was instructed to attend domestic violence group sessions but failed to do so and was marked as an unexcused absence. The offender was considered a parole absconder since 10/9/24, at which time Explorer was notified and was unsuccessfully discharged from the program on 10/24. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the remand to custody, Exhibit B, the notice of parole violation, Exhibit C, the parole violation report, Exhibit D, the conditions of parole, Exhibit E, the voluntary admission 9/9/24 and misconduct, Exhibit F, the voluntary admission 9/15/24 and misconduct, Exhibit G, the Explorer discharge report 6/27/24 and misconduct, Exhibit H, the Explorer discharge report 10/16/24, and Exhibit I, the waiver of extradition. In addition, the state did file an addendum to the parole violation report that states that on 11/4/24, the Board of Parole issued a warrant based on the report declaring the offender an absconder from parole supervision. And on 12/10/25, Rivera Garcia was apprehended by the Puerto Rico law enforcement and charged as a fugitive from justice. He was served his notice and parolee rights on 1/9/2026. So, counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes.
Excuse me, thank you. And I did receive exhibit from the defense. I have Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any other documents?
No.
We don't have any witnesses today. So at this time, the defense will have an opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. So, counsel?
Yeah, thank you. We don't have any comments as to the charges. Just want to be heard on his background and history.
Thank you. So I am going to announce my findings, Mr. Rivera Garcia. So on charge number 1, I am finding that you violated the condition of reporting based on the evidence presented in state's exhibits C and D. On charge number 2, I'm also going to find that you violated the condition of absconder based on the evidence presented in state's exhibits C and D. On charge number 3, I'm finding you violated the condition of drugs based on the evidence presented in state's exhibits C, D, E, and F. On charge number 4, the condition of travel, I'm finding you violated that condition based on the evidence presented in state's exhibits C, D, and I. On charge number 5, I'm finding you violated the condition of behavioral management program based on the evidence presented in state's exhibits C, D, G, and H. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what I recommend. So, counsel?
Yes, thank you. My client is 49 years of age. He's divorced. He does have 6 adult children who reside in Puerto Rico. In addition, my client has 3 brothers, 4 sisters who also reside in Puerto Rico. His family support is primarily made up of his siblings as well as his children, as well as his significant other who resides in Connecticut. My client does have his GED. He also studied culinary arts while at McDougall Walker through the vocational education programming there. He was in the community for approximately 5 months prior to this violation. This is his first violation of his parole. Unfortunately, his decision to abscond was directly related to his brother's illness, his brother who resided in Puerto Rico. My client was there. He was able to assist his family as well as his brother, becoming a caretaker for his brother, who ultimately passed away in May. During the time period that he was in Puerto Rico, he reports that he was not using any illegal substances. He was not committing any new crimes. He did try to speak with his parole officer about transferring supervision to Puerto Rico, trying to do it the right way. However, he was unsuccessful. After his brother passed away, he did make attempts to contact his parole officer. However, he no longer had that contact information and he did not have the funds to travel back to Connecticut. During his time period that he was on supervision, he reports being the assistant manager at Burger King and Waterbury. And then during the time period that he was in Puerto Rico, he reports being employed working construction. He does have successful treatment periods from January 16th of 2024 to March 15th of 2024. He did successfully complete intensive outpatient treatment program. And then I just want to correct in Defense Exhibit 1, the dates on one of his treatments. 5/25, it's reported, we listed it as 5/25/26, and that's obviously inaccurate. But during that period, it's 2024. He participated in relapse prevention programming, and we did receive documentation that indicated he successfully completed 6 sessions as well as rendered all negative drug screens during that period. During the period of time that he's now been within the Department of Corrections, he reports being on the waiting list for employment as well as vocational education, reports participating in religious services. When he is reinstated to parole, he's asking to be placed in a halfway house in the Hartford area. His ultimate plan is to transfer his supervision to Puerto Rico, where the majority of his family is, if not all. He's open to all employment opportunities as well as all treatment recommendations. And again, this whole entire violation stems from him leaving, which was due to the illness of his brother. He did give me, his mother passed away on May 8th of 2025. I also would note that I believe he was taken into custody on December 16th of 26. No, of 25. Yeah. December 6th. Is that accurate?
December 10th.
December 10th?
Yeah, 2000.
You know that 2025, correct?
Yes.
Okay. I think he signed his paperwork to be extradited maybe on the 16th, but was in custody on the 10th. Would just be asked that he be given credit for that time period since he was in custody there. And then Mr. Rivera Garcia, is there anything that you want to add?
No, I just got the deposition papers from my brother. Yeah.
Okay.
The counsel you mentioned, he passed May 8th, correct?
Yes.
Yes.
Thank you. Anything further?
Nothing further.
Just gonna take a moment, then I'll announce my recommendation. So I have listened to the testimony today. I reviewed all the evidence provided. Based on that, Mr. Rivera Garcia, I'm going to recommend that well, I do want to just note a few things first. This is your first violation on special parole. You were in the community for approximately 10 months, I have, because you were on discretionary before, correct? Before it switched to special parole.
Yes.
You did have the 3 misconducts with the 1 discharge from exploratory positive drug screens. And you were unaccounted for approximately 14 months in Puerto Rico, as you just explained your brother was ill, which is what triggered you to leave. So with that, Mr. Rivera Garcia, I'm going to recommend your parole be revoked and that you serve an approximate 6-month period of confinement as a sanction. That's with the re-parole date of June 10th. That's with the credit from your arrest in Puerto Rico. All right, now I'm doubting everything in my brain. Let me just do my math quickly, okay? Because I'm not very good at it.
No problem.
6 months? Okay, so June 10th, 2026. I'm going to recommend the following conditions. Behavioral management program for domestic violence. Please try to get it done, okay?
Yes.
No contact with victims, SGM and DL. Mental health evaluation and treatment as deemed necessary, and problem sexual behavior treatment. And I'll do halfway house placement with the Hartford location. So what happens next, Mr. Rivera Garcia, is that I'm going to send the recommendation to the parole board next week on April 16th. On that date, the board can do 3 things. They can lower my recommendation if they choose to do so. They can adopt it if they choose to do so. And if for any reason they would want to see a longer period of confinement as a sanction, they'll ask you to come back for another hearing to address their questions and concerns before anything longer is imposed. I do also just want to stress to you, Mr. Rivera Garcia, you are on parole for a very, very long time.
Yes.
So
No,
all this does is extend it, just so you're aware. If you do abscond, it doesn't just go away, it's added on. So right now you're going to 2040. So just try to be mindful about what unfortunately your obligation is to this, okay?
Yeah, and I can add one more thing. I want to apologize to the parole because they gave me the chance, but my brother was so important for me because he got no arms at all. So I was trying to help my mom. That was all. That was it. Thank you.
Understood. Yeah, just like I said, you're unfortunately with us for a very long time. So
Yes,
when
ma'am.
you abscond, it's just added. It's not gone. It doesn't go away. We don't forget about you, fortunately. So just be mindful, okay?
Yes, thank you.
That does
Appreciate
conclude today's hearing. Do you have any questions?
No, everything is fine, and I want to thank you, my lawyer. Thank you for letting me know everything, and I'm so sorry. Thank you.
Well, good luck to you.
Good luck, sir.
This
Thank
concludes
you.
the revocation hearing for Juan Rivera Garcia, inmate number 415234. All right, good luck, Rivera Garcia.
Thank you. Have a nice and a beautiful day, both of y'all. It's over. It's done. All right. Think so. Is all?
You can leave.
It's-
You're good.
Oh,
Yep.
okay. Thank you.
Thank you. Good morning. Good morning. Good morning, Mr. Sanders. How are you?
Good, and you?
Good. So it is 10:59. We have just a minute and then we can get started, okay?
Okay, no problem.
All right, so we're gonna get started, okay?
Yes, ma'am.
All right, so good morning, I'm Parole Officer Trisell, and I'm the hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Steven Sanders, inmate number 314697. Today is Monday, April 6, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborne Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Steven Sanders, inmate number 314697.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Sanders.
Thank you. And counsel, you just mentioned that,
Yes, my client was referred to the timeout program. With that being said, he's waiving the first portion of the hearing and asking to move to his eligibility finding.
Thank you. And Mr. Sanders, you're in agreement with this?
Yes, ma'am.
Okay, so I am going to accept the waiver on the record today. The case for the finding portion will be reviewed administratively and will be sent summary in the mail with that information. So we are going to move on to the diversion program part of this hearing. So, Mr. Sanders, the Department of Corrections has recommended you for the diversion from the revocation process for substance abuse programming and treatment. What that means that if you wish to participate and apply and I find that you meet the eligibility criteria, I can continue your case while you are provided an opportunity to participate in substance abuse programming and treatment in the correctional facility. If you successfully complete the programs and a treatment provided, I will then dismiss your case and order your parole reinstated. If you do not complete the programs and treatment provided, the board will then schedule and convene a revocation hearing to determine whether you have violated the conditions of your parole. And if so, at that time, the hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. So Mr. Sanders, I do want you to know that to participate in the diversion program, it's completely voluntary. So do you understand the process and do you wish to apply for it?
Yeah, the timeout program.
The timeout program, yeah.
Yes. Volunteer for it. Yes.
Okay, perfect. So we're going to go over the eligibility determination for the program. I'm going to announce my findings with respect to that. So I am going to find that you have no pending misdemeanors or felony charges. I'm also going to find that your discharge date is more than 60 business days from the date of remand to actual custody. I also find that there's evidence that you've identified substance abuse treatment needs. I find that substance abuse is a reasonable consideration, reasonably considered to be a motivating factor in your alleged failure to comply with the terms and conditions of your parole. And I also found that there's some evidence that you received and were provided an opportunity to receive substance abuse programming and treatment while you were in the community on supervision. So I am going to find that you are eligible for the diversion program at this time for the top program. But before I accept your application, I am going to ask that you indicate whether or not you understand the following by answering yes or no. So the first is that I understand that I will remain incarcerated while I receive programming and treatment and that parole revocation proceedings may be delayed as a result. Do you understand?
Yes.
I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and it's conditioned upon my successful completion of substance abuse programming and treatment.
Yes.
Perfect. I understand that ultimately the Department of Corrections will determine whether I have successfully completed the substance abuse programming and treatment provided.
Okay, yes.
And I understand that my participation in this process is completely voluntary.
Yes.
Perfect. So I am going to accept your application and it, for the diversion and it's granted. So it seems like you probably are already in treatment, correct?
Yes, ma'am. I've already started the classes.
Okay, great. So once you're completed, the counselors there will notify your supervising officer and they will notify us of your completion date when you're finished with it. And then we'll reinstate your parole effective whenever that date is. Okay.
Okay, ma'am.
Do you have any questions?
My only question is, there was an issue prior to me coming in regarding my sponsor. I was under the assumption that my stepdaughter and her husband, because when I was in the parole board last time, I was under the impression I gave both names, Felix Cruz and Nelsie Cruz together, same address, 68 John Street, etc. My stepdaughter and her husband ended up getting divorced. She ended up moving out, and I had told the parole officer about this. And then he said something about a lease, which I didn't understand why he would need a lease at that time, which my address never changed. She just had left the property, and he said that she was my only sponsor. But like I said, I was under the assumption that both Felix and Nelsie Cruz were my sponsors. So I would like to continue to have Felix as my sponsor, please, and thank you.
Yeah.
I would really appreciate that.
Trying to think of the best way to do this. So the problem, Mr. Sanders, is that I have no control over anything with housing.
Okay. I just wanted to state that for the board, that's all.
Well, and I want to write it. What's Felix's last name?
Cruz.
Cruz, sorry. So
No,
I will
okay.
note it and write it in the summary that I have to complete for your case.
Yes, ma'am.
And I can just do that. It might be in your best interest to maybe write a inmate request and
Oh,
ask
okay.
a counselor if they can forward the information to your supervising officer, because whoever you report to in the community is the one who handles housing.
Okay,
I don't know if you know who, I don't know, I don't even know who his officer was. Oh, Del Payne. So you can try to get a letter or call to Del Payne. I don't know if
Okay.
they'll help you with that, or just ask your counselor to like get the information to him. Same thing, just provide him with the full name, address, phone number,
yes, ma'am.
everything you needed to in the past, and that way they can coordinate it before you're completed with the program.
Okay, all right, thank you.
All right, any other questions?
Not at the moment. Thank you, guys.
All right, so this does conclude the preliminary hearing for Steven Sanders, inmate number 314697. All right, good luck to you, Mr. Sanders.
Good luck, sir.
Thank you. Thank you, guys. Have a nice day.
Yeah.
Standards.
Hello, good morning.
Good morning, how are you?
I'm good, thank you.
Good.
Please give us a few minutes. She's running late. She will be here shortly.
No problem, thank you.
Thanks. And that is for Munoz, is that?
Miss Bass, Jasmine
Okay,
Bass.
okay, yeah, that. Sorry.
Thank you.
Oh my God, yes, another one I need to run down there immediately. 11. I don't want to take anything. Back. Oh no, she needs to run down. Back. I need to be quiet. I don't know what happened, but I saw on the camera to do something. Saw on the camera to do something. And I don't want to do anything. I just do that. It's not anything. Oh, it's take control, right? Let's try to put this thing back on. Before I put the lid,
Good morning, Officer Castillo. How are you?
Good morning, how are you?
Good, thanks.
Oh.
Good morning, Officer Saunders.
Hi, good morning.
Is Officer Sheehan still coming?
Yes, I just sent her a message.
Oh, great, thank you.
You're welcome.
Because some judges and speakers, majority. She's on her way, please. Yeah,
Okay, no
she's
problem.
on, yeah, she's on the walkway.
Okay, thank you.
Just when you thought you were on schedule, huh?
It's so on schedule, yeah. It's not easy to do either.
I know, but you were doing pretty good. I mean, it's only 11:16 and now we.
Yeah, so close.
Right.
Sheehan's attempting to log in now.
Okay, perfect. Thank you.
You're welcome.
Good morning, Ms. Bass. How are you?
Good, how are you?
Good. We're just gonna wait another minute. We're waiting for one of the officers to log in and then we'll get started, okay?
Okay.
I think Sheehan's having difficulties logging in.
Kristen, are you around?
I saw that she just came online in Teams, so I've pinged her to get a pop-up to join.
Okay, so we can get started. Good morning, Officer Shan. Oh, you're muted. Can you hear us? Yeah, we can't hear you.
Thank you. Sorry about that. I'm having technical difficulties today.
No worries. We're gonna get started. So good morning. I'm Parole Officer Trisella. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Jasmine Bass, inmate number 357723. Today is Monday, April 6, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in your correctional institution. Can you please state your full name and DOC inmate number for the record, please?
Jasmine Bass, 357723.
Thank you. And this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mrs. Bass.
Thank you. And also present are your charging officers. Can you all please identify yourself for the record?
Parole Officer Saunders with the Women's Reentry Unit.
Parole Officer Sheehan with the Women's Reentry Unit.
You're muted. Sorry, Officer Castillo, you're muted.
Parole Officer Jessica Castillo with the Women's Reentry Unit.
Thank you. Counsel?
Yes, thank you. My client has been referred to the top program for diversion. So at this point, we would waive the first portion of the hearing and ask to move to her eligibility. Thank you.
Thank you. Ms. Bass, just to confirm, you are in agreement with your attorney?
Yes.
Okay. So I am going to accept the waiver on the record and we'll move forward with the determination for eligibility for the diversion program. So the Department of Corrections did recommend you for diversion from the revocation proceedings for substance process for the substance abuse programming and treatment. This means that if you wish to participate and apply and if find that you meet the eligibility criteria, I will continue your case while you are provided an opportunity to participate in substance abuse programs and treatment in the correctional facility. If you successfully complete the program and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the program and treatment provided, the board will schedule and convene a revocation hearing to determine if you violated the conditions of your parole. If so, the hearing examiner will make a recommendation regarding whether or not your parole should be revoked and what, if any, sanctions should be imposed. So, Ms. Bass, I do want you to know that participating in the diversion program, which is TOP, is completely voluntary. So do you understand the diversion process and do you wish to apply for it?
Yes, please.
So I'm going to announce my findings with respect to your eligibility for the program. And if I determine that you are eligible, I can accept your application and then divert you from revocation. So the first one is that I am finding that you have no pending misdemeanor or felony charges. I also find that your discharge date is more than 60 business days from the date of remand to actual custody. I also find that there's evidence that you have identified substance abuse treatment needs. I find that substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with the terms and conditions of your parole. And I also find that there is some evidence that you received or were provided with an opportunity to receive substance abuse programming or treatment during your period of parole while in the community. So with that, Ms. Bass, I am determining that you are eligible for the TOP program at this time. Before I accept your application for the program, I do ask that you indicate whether or not you understand the following by answering yes or no. So the first statement is, I understand that I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result.
Yes.
I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of substance abuse programming and treatment.
Yes.
I understand that ultimately the Department of Corrections will determine whether I have successfully completed the substance abuse programming and treatment provided.
Yes.
And lastly, I understand that my participation in this process is completely voluntary.
Yes.
Okay, thank you. So I am going to accept your application for the diversion and it is granted to you. So I don't know if you have started yet, Ms. Bass, but if not, you'll start treatment in the facility. And once you are completed, one of your charging officers will be notified to let us know that you've successfully completed that program, and we'll reinstate your parole effective whatever date that is, okay?
Okay, thank you.
Do you have any questions?
No, not at this time.
Okay, so that does conclude the preliminary hearing for Jasmine Bass, inmate number 357723. Good luck, Jasmine.
Thank you.
Thank
All
you.
right, thank you.
Thank you.
Have a great day.
Too.
Thanks.
Yes, and that's what really.
Hello.
Good morning. How are you?
Good. How are you?
Good, thanks.
You have two scheduled. I don't know which one you want to see first, or does it matter?
If possible, if you can get McBean down, that would be
Okay.
first, just because I have an attorney and an officer for him. So yeah, that'd be great.
Okay, they're on their way up now.
All right, and if not, whoever's there first, whatever, it's
Okay.
easiest. All right, thank you.
No problem.
Good morning, Officer Huff. How are you?
Good morning. Good. How are you?
Good. We might be starting with the other gentleman first, but it's also, I told the CO, whoever comes down first.
Okay. Sounds good.
Thanks. And Officer Pearson, are you with us?
Pearson is right here, actually.
Oh, is he? Oh, he's gonna sit with you? Oh,
I'm having to use his
hi.
computer.
That's fine. Yeah, it's fine.
Yeah, you're having issues still. We
Yeah,
saw.
still having
You're-
issues. I did a help desk ticket, but they haven't gotten back to me yet.
Okay, so I mean, if you want to share, you can share, whatever you
Yeah,
guys
we'll
want to
tag team.
do. Yeah.
I'm gonna go get my
Whatever.
paperwork. I'll be right back.
All right, sounds good. Thank you both.
No problem.
Hi, Huff.
Hi. Oh, he's saying hi to you, Huff, not me.
Hello, who's that?
How you doing, man?
Good. How are you?
Good.
Oh, what's up, man? How you
You gave him
doing?
a PO?
Yeah, decided to come out here, switch things up a little bit.
Oh, there you go.
Definitely. It's a good gig. How's things
Yeah,
for
there you
you?
go. Not bad. Just hanging out.
Nice, that works.
Oh, yeah. I think he's here now. I'll go get him.
Thank you.
Thanks, man.
Just gonna step out. I need to go over the problem with the guy I stayed this morning. So this job is. I'm just gonna step out for a minute, Officer Huff. I just need to go let my supervisor know something. If whoever comes in the chair, if they say anything, Officer Menard's here.
Sounds good, thank you.
Ready? Yeah, just have a seat there. This camera should adjust.
Yeah, the camera has an AI facial recognition. It'll move automatically after a few minutes.
Supposed to.
Yeah, some of them are slower than others.
All right. Just knock when you're done.
Yeah.
Containers in DOC twice.
Right. Sorry about that, Mr. McBean. I just had to go tell my supervisor something quickly. I have to wait for this to turn on. All right, so good morning. Is it time? It is time, right? Yeah, so good morning. I'm Parole Officer Chiselle, and I'm a hearing examiner for the Court of Pardons and Paroles. And I do just want to know on the record, this is a revocation hearing for Neville McBean, MA number 122908. Mr. McBean, before we get started, I do have Attorney Dean here to give some information on your attorney situation.
Yes, thank you very much, Mr. McBean. I apologize, I haven't been able to speak with you. I've been trying to set up a call with your counselor to let you know an update regarding your case. So our office did speak to an attorney who is gonna be representing you for this matter. She was just requesting a short continuance so that she may meet with you and discuss everything. And I believe she was asking for 4:15.
So would you like to continue today's hearing one more time to 4:15 to speak with your new attorney, Mr. McBean?
No, I'm waiving that. I'm waiving that attorney stuff because it's just holding me in. It's just
prolonging this process, and it should have been over with last month, so I'm just waiving it.
Okay, so you want to move forward today without legal representation?
Yes, I do. Thank you.
All right, thank you, Attorney Dean.
Thank you.
All right, then we're gonna get started for real then, okay, Mr. McBean? So this is a revocation hearing concerning Neville McBean, inmate number 122908. Today is Monday, April 6th, 2026, and this hearing is being conducted via video at the Board of Pardons Central Office at McDougal Correctional Institution. Can you please state your full name and DOC inmate number for the record?
122908.
Can you state your full name for me, please?
Neville McBean.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your charging officer. Can you please identify yourself for the record?
Parole Officer Pearson with the residential unit.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. McBean and Officer Pearson, can you both please raise your right hands? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, I do.
Thank you. So we're going to go over the procedure for today, Mr. McBean. So first I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings, and if I find that you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
None.
Yes, you do have questions?
No questions.
No questions. Okay, so we're going to go over your rights for today's hearing. So the first is you do have the right to be represented by an attorney. However, I did hear you state that you are willing to move forward without representation. Is that correct?
Yes, ma'am.
Right. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, ma'am.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
I'm ready to move forward. I understand all my rights.
Perfect. So we are now going to review the charges that the state, your parole officer, is bringing against you and the information underlying the charge. So Officer Pearson, can you please review the charge for us? Number 1, halfway house placement.
Yes. Charge 1, halfway house placement. On November 2nd, 2025, offender reported you threatened them at 7:20 a.m. The threat consisted of you saying, if you don't plug the microwave cord back in when he's finished, you will punch him in the face. You don't care about the security cameras. You were seen on video surveillance getting in the face of another offender and being aggressive with body gestures. You are in violation of your halfway house agreement, which states, I will treat others with respect and not engage in verbal or physical altercations with other offenders. On November 13th, 2025, this PO toured the halfway house and spoke with you. You verbalized needing winter clothing and that the halfway house is not helping you and that you will go out and commit crimes to get what you needed. This PO informed you to consult with your case manager and halfway house manager. This PO even spoke with the job coach who reported she will let you pick out clothing from the halfway house clothes in storage. You declined. Later on in the evening, you became upset and irate in the halfway house. This PO was paged after hours as you reported you were going to commit crimes to get what you needed. You also made a comment of if this PO has a gun, you can have access to guns as well. When this PO spoke with you and the halfway house manager via speakerphone that evening, it was confirmed halfway house manager placed you on the wait list for CRT, CHS, and the Hartford Welcome Center for a closing voucher. You still reported you would commit crimes to feed yourself. You were informed by this PO that you received free food at the halfway house and clothing has been offered, which you refused. This PO inquired about your gun comment and if you wanted to recant your statement. You chose not to and reported you have access to guns too, but they were not in the halfway house. You told halfway you have a Jamaican family and they live up the street from the halfway house and you can have access to their guns. You also informed halfway house staff that you are not going to any treatment programs. You are in violation of your halfway house agreement, which states, I will treat others with respect and not engage in verbal or physical altercations with other offenders. On November 26, 2025, you went out for a smoke break around 9 p.m. at the halfway house. During the scheduled smoke break, you began arguing with other offenders regarding an alleged missing cigarette. An offender informed you that no one took your cigarette and everyone had their own supply of cigarettes in the storage box in the staff office. You were also reminded that you have been supplied cigarettes by other offenders during your stay at Eileen O'Connor halfway house. You became increasingly agitated and stated, I don't care if I go back to jail. You are in violation of your halfway house agreement, which states, I will treat others with respect and not engage in verbal or physical altercations with other supervised persons. On December 12, 2025, you were overheard by another offender in the halfway house having a conversation on the phone about having access to guns from your family member up the street and shooting up the halfway house. On December 19, 2025, this PL met with you in person along with the halfway house manager and your case manager to discuss the accusation. You denied making the statements and were reminded that you have made these exact same statements in the past, and now an offender is reporting these concerns. You then stated, now I can't have a conversation on the phone. You were informed those types of conversations are a cause for concern and against your halfway house agreement, which states I will treat others with respect and not engage in verbal or physical altercations with other supervised persons, staff, or third parties. You were also informed by this PO to cease talks about guns, shooting up the halfway house, or causing physical harm to people, or this PO would be recommending a remand for your next offense. You agreed. On December 26, 2025, this PO was provided a recording of you making an egregious threat to a third party. You stated, I'll snatch that bitch ass motherfucker off the street. I'll come up and chop his fucking ass up and be back at the halfway house. I hear him in the background mumbling. Don't worry, I got something for his ass. Tell that bitch ass motherfucker I'll wrap his fucking head in the towel and soak it in fucking gasoline and light it up. I'm coming out there. Halfway house manager also reported offender threatened to break the legs of offender Domenico Conoce, inmate number 199344, and crack his head open. You are in violation of your halfway house agreement, which states I will treat others with respect and not engage in verbal or physical altercations with other supervised persons.
Thank you. So the evidence submitted by the state was already identified at the preliminary hearing, and that all does remain the same. So Mr. McBean, just to confirm one more time, you did receive the notice of parole violation, the parole violation for, and all the other documents identified for today's hearing?
Yeah, I received it.
And you were able to review all of it?
Yeah, I reviewed it.
Perfect. I have not received anything from you at this time. Do you need time to submit any evidence for your own behalf?
The only thing that Attorney Dean didn't have was a copy of that audio recording of a resident at the halfway house recording my cell phone conversation, which is in itself a violation of the halfway house rules. We're not allowed to record staff, the program, or another resident, but that's what the evidence is based on. It's based on an illegal recording of my conversation. You know, that's clearly a violation of Connecticut state law itself. I wasn't notified that my call was being recorded. That's a violation of the wiretap law itself.
So I'm just, so that was going to be.
And y'all using the same evidence that was obtained illegally at my parole revocation hearing.
So
It's
just to
already been
confirm,
cited.
so the evidence submitted by the state is the recording, and your argument towards that piece of evidence is that it was obtained illegally, correct?
Exactly. In violation of the Connecticut General Statutes wiretap laws. I signed a paper on November 14th, as well as all residents at the Elaine O'Connor halfway house. The job coach, as well as Joe Gallant, informed us that our parole officers wanted us to sign this paper. So every resident signed this paper, and it clearly stated that we are not allowed to record staff, residents, or any part of the program with our cell phones. And that's how that recording was obtained, was through a cell phone. I'm not denying that I had a conversation. I'm just not understanding it.
Yeah, so I noted what your argument towards Exhibit S is. I'm gonna keep it. We're gonna get back on track because this is a state's case against you. So I want to go towards the procedure and let them state their facts before you get started. Actually, like defending yourself at this point. Okay. So I did make the note that you are objecting to Exhibit S, that it was obtained illegally as you signed a document with the halfway house staff. So at this time, I am going to let the state respond, make a statement, present evidence, and speak to any of the evidence submitted. So Officer Pearson, any comments towards the charges at this time?
Comments towards the charges.
I'm sorry, I missed it. What'd you say?
No additional comments towards the charges.
Okay, thank you. All right, so Ms. McBean, now is your opportunity to respond to the parole violation charges against you. However, I do want you to remember that you do have the right to remain silent if you choose to do so. So at this time, would you like to testify regarding the charges that are in front of us against you?
I got a few issues with the charges because, I mean, the alleged allegation from November 2nd, how does that play into what happened, what supposedly happened on November 13th or whatever, and a resident claiming that he heard me in a conversation talking about bringing a gun to the halfway house and shooting up the halfway house. And then in this same report, whoever wrote the report, they clearly state that that stuff was not, it had no evidence to it, but it's being used against me in the paperwork that y'all compiled to bring forth and charge me with. It clearly states there was no evidence that this even happened, but it is put in the paperwork, and it's being used against me. I gotta defend myself against it. It's just hearsay. It's just my former roommate that don't like me, and he know I don't like him, and so he's gonna say whatever he's gonna say. He's gonna be believed because supposedly he has Alzheimer's. He's older than me. That don't mean anything to me. The point is, I was lied on. You know what I'm saying? I was lied on, and at no time did I ever state that I had access to a gun. I said, my family has access to guns that live up the street from the halfway house. And based on the fact that that's my family, that is what it is. If I wanted to get a gun, I think I would have had a gun. You know what I'm saying? You can look at my criminal history and you can clearly see by my criminal history, I have never committed any crime with a firearm. Absolutely never. My criminal history dates all the way back to the early 80s. Never have I ever committed crimes with a firearm. Never have I sold drugs. Those are crimes that people normally have firearms in, drug selling. I don't do drug selling. I don't do armed robberies. I don't do none of that stuff. I don't have a need for a gun. I'm not a homegrown terrorist. I don't have a need for a gun. I had a conversation, like Mr. Pearson said, he had this conversation with me over video, over the Joe Gallant's phone in his office. And I went back to my room and I explained to one of my roommates, you know, what what me and Pearson and Joe Gallant talked about. So this is how that information from that conversation got into the ears of my roommates. That's where it's coming from. I didn't have an additional conversation about guns in the halfway house. It's just that I went back to my room and I explained to them why I was in the office. So they took it, one of those guys took it upon themselves to run this story, keep talking about it. I didn't keep talking about it. I have no need to keep talking about it. You know what I'm saying? I was held accountable for it. I did whatever sanction, whatever punishment was given to me, I did it, and I kept it moving forward. I just don't like the way I was being played at that halfway house. You know what I'm saying? Trying to make me seem like since I've been there, I've been this energy that affects the entire halfway house. The halfway house is the size of a shoebox. You got 22 people living in there. Obviously, there's going to be people bumping heads, not getting along. That's a small halfway house. It is nothing like the Cheney house, which is a big apartment building. There's a lot of room in the Cheney house. I would have never had that incident at the Cheney house if that clown would have never unplugged the microwave. I put my food in the microwave, and yes, he unplugged the microwave. You know what I'm saying? All this stuff he's talking about, me doing this crazy stuff to him, I didn't say none of that stuff to him. There was other residents in the kitchen that witnessed the whole exchange. I just told them straight up, listen, man, if you want to mess with me, just understand this. These cameras in here, these cameras pick up everything. These cameras have microphones on them. They hear everything. So if you want to unplug the microwave, you're on camera doing it. I'm not going to bring the staff into this because I'm not trying to sabotage another resident's halfway house placement. That's not how I do my time. You know what I'm saying? I don't go to COs in here and complain about another inmate. That's not how I do my time. And Pearson had a conversation with me, him and Joe Gallant, about that type of way I do my time. I can't get on board with that. I can't get on board with being the eyes and ears for staff. I can't do it. And if they don't like that, that's something they just gonna have to not like about me because I'm not doing it. No matter what halfway house I go to, I will not be the eyes and ears for the staff. That is not my job.
Great. Well, thank you, Mr. McDean. I appreciate your statements. Officer Pearson, anything to follow?
I think in his statements that he made, he admitted to a comment about the toaster on November 2nd, and he admitted to having that conversation about the guns and threatening another offender in the halfway house because he's talked about the illegal wiretap from his roommate. So, I mean, I think he has to take into considerations, like I told him in that meeting that we had, is that he can't have that kind of verbiage in the halfway house. Other people can report that because they're fearing for their safety and the safety of the third party that you wanted to wrap a towel around their heads and soak them in gasoline and burn them. You made those statements. You signed the misconducts, and it was in the incident reports that you signed that you made those statements.
Mr. McDean, anything additional before I do announce my findings?
But see, I don't want to do the tennis match volley back and forth.
Correct.
I mean, it is what it is. You know, there's the audio recording. How it was obtained was illegal. Okay, in the court of law, you still have to find that that's me on that audio recording. And if it is on me on that recording, then it was obtained illegally. And Hartford police was notified. The state police was notified. There was no crime committed. There was no crime committed. Now, I understand what y'all mean by I violated the terms and conditions of my special parole because I supposedly violated the rules in the halfway house, which I don't understand how that can be a condition of my parole. Because my conditions came from the judge, and according to Connecticut General Statutes, the Board of Partisan Parole can add additional conditions. So was the rules at this halfway house additional conditions? Because I don't got no paperwork stating that those rules at this halfway house were or are additional conditions. And if that's what, and if that's what y'all alleging is I'm violating of, then I will guarantee you, I will never sign another piece of paperwork as long as I'm on special parole to a halfway house.
So
I cannot do that. I cannot do that because then
Mr. McBean, we're gonna let Officer Pearson respond. Yeah, because he.
Mr. McBean, you're fully aware that when you go to the halfway house, there is rules in the halfway house, which is called the halfway.
I'm 100% aware. 100% aware.
Which are
what
called
I can't understand is that.
Which are called the halfway house agreements.
Mr. McBean, let him respond, and then you can respond back. Sorry.
The halfway house agreements that are in evidence that you signed on 9/19/25 and 11/14/25. You signed those. Now, I just wanted to make comment on what you just said. If you don't want to sign any of those conditions, your special parole conditions, and you don't want to sign your halfway house conditions, that's totally up to you. But then what would happen on my end of things is it was seen that you're not being compliant with your conditions, and then you'll be remanded back into custody.
So how come you can't put me in a reach apartment?
You don't qualify for reach. So to be in a reach apartment, you have to be released from prison for 45 days in the halfway house. You have to be employed. You're not employed, or you have to be collecting disability, right? You have to be compliant for at least 30 days. You haven't been compliant because you have several misconducts that are in the evidence of this PVR, right? So until you meet those requirements, you can't go to a reach bed. That is a privileged placement. It's not a mandatory placement. So if you come back out again, right? Are you collecting disability?
Well, can I stop you guys quickly though? Can we get back on track to,
Sure.
We'll get to that second part if we move on to that second part. So I'm gonna announce my findings now unless there's anything additional towards the charges at this time. The charge specifically, no? Okay. So I'm just gonna make my findings towards the charges and then we'll move forward if that's needed. So I have listened to the testimony presented by both Mr. McBean and the state at this point, and I've reviewed all the evidence submitted. So with that, Mr. McBean, on charge number 1, the condition of halfway house placement, I am going to find that you violated that condition based on the evidence submitted in states exhibits B, C, F, G, H, I, J, K, L, M, N, O, P, Q, R, and lastly, just T. So that does conclude the fact-finding portion. Before we do move on, the state will have an opportunity to speak to your background and history, and then you'll have the same. And the purpose of this part of the ratification hearing is to help determine what outcome I will recommend. So, Officer Pearson, anything additional, if you want to provide any additional information to Mr. McBean about the placement?
On the placement in the halfway house or the placement at reach?
Well, you were going to keep going with the reach placement and what you expect. That's what I thought I was hearing.
I was just going to give him the requirements of reach. So once again, if you come back, when you're re-released back into the halfway house, you would have to be there for a period of 30 to 45 days before you can apply for a reach bed. You would also have to be employed or collecting disability because you have to be able to fund living at the reach bed. It's not free. You have to be discipline free, which means you have to be in compliance with your halfway house agreement and your special parole conditions. If you get written up, doesn't mean that you can't go, but from the day of that write-up, you have to wait 30 days to be clear, to be considered again. So you need to meet those requirements.
Thank you. And anything further, Officer Pearson, about Mr. McBean's background and history that you want to know on the record?
I mean, from the incident from November 2nd with the toaster incident, I moved him from one halfway house to another halfway house. And it seems that his episode of violence has just continued to follow him. And he admits it and then he recants his admission. So, and through this testimony, he's already proven that he did make those statements. So I don't have anything else to say.
Thank you. And Mr. McBean, any statements or comments towards your background, your history, what your future plans are for when you go back out in the community?
It's hard for me to answer that question truthfully because I have absolutely no contact with nobody from the Board of Partisan Parole while I'm in this facility. I did, however, ask Officer Pearson that when I am eventually released again, if I can be moved to, if my special parole can be moved to Middletown to the Eddy Center. And he said he'll put that in play. However, that's supposed to go, I don't even know. But I know he put it in one of the papers that I seen that y'all sent me, that I requested to be the Eddy Center thing. I just don't want to go back to Hartford because the Cheney house was in the neighborhood where my instant offense and all of that stuff happened. And then I was moved to, I mean, y'all don't know these things. Y'all know that, but y'all didn't know about the Board of Partisan Parole, didn't know that I don't get along with my father's side of the family. That's the Jamaican side of my family. They live right on Irvin Street, right on Magnolia Street, on Martha Street. So it's like I was put in an area where I didn't want to be at. I told Joe Gallant that when I first got there. And the other thing y'all didn't know at the Cheney house was that I had a family member working there. You know what I'm saying? I was very uncomfortable with that because she's on the Jamaican side of my family. I told the former correctional officer, Ms. Ross, that. I said, Ms. Ross, I'm related to this lady. How am I in this halfway house?
So moving forward, a different location's better. Officer Pearson is Middletown. I don't know how to put that on a disposition. Would that still be Hartford District, should I do?
It'll be Norwich.
The Norwich District? Okay. All right, so Mr. McBean, I'm gonna put the information that you've requested at Eddy Center. Obviously, it's not up to me, it's up to Parole and Community Services to place you in whatever's available. So we'll do the Norwich location at Eddy Center. Do you have any plans for employment or anything of that nature?
I was dealing with this.
So
my disability.
You receive disability? You do?
No, I don't receive it. I was dealing with this. I was scheduled for everything to move forward in January.
Okay, so you need to have surgery.
I need to I gotta reapply now because that appointment was canceled out because I was remanded.
Okay, so you need to have surgery or you need an appointment to apply for the disability? Yes. Both? I was
scheduled for orthopedic surgery stuff in UConn when I was at the halfway house, but since I was remanded, that was rescheduled. DOC rescheduled that because I know the date when that thing was going to go down, so they rescheduled it. So I'm waiting right now to actually go. Okay. And are you planning to apply for disability? Is that the overall plan, or do you feel like after your surgery you're going to look for employment? There's no way I can work again. I got spinal stenosis, and it's progressively getting worse. My balance is getting worse. I'm dizzy all the time. You know? Okay. So you'll look into applying, getting some help to apply to get the disability income? Yeah, I need all of that stuff. And additionally, all of my property was thrown away. Joe Gallant said a family member picked my property up. I'm in no contact with none of my family. Absolutely none. You can have the security division in DOC check my phone stuff, check my mail stuff. They will tell you, I just did 14 years, no contact with my family. How did my family pick my property up from the halfway house? I'm in no contact with my family. I do not deal with my family. Yeah, so, I don't property was thrown away. Yeah, I'm not sure how we get, sorry, go ahead, Officer Pierce.
Who was your emergency contact?
I don't have an emergency contact.
Well, I'll look into it.
Absolutely none.
All right, so he said he's gonna look into it for you before you're back in the community, okay? Yeah. Anything additional about your plans for reinstatement before I make my recommendation?
I don't think I deserve what Officer Pearson recommended, 6 months remand, all this no contact stuff with people, that there's no crime against this, something else, the anger management stuff. I was doing all of that stuff in the community already.
Well, I appreciate you talking to me. Any further comments from either side before I do announce my recommendation?
None for me.
Pearson, anything additional?
No, I'm just trying to text the halfway house manager right now, but I don't have anything additional.
All right, then I'll just gonna take a moment. I'll announce my recommendation.
Oh, I did have one more question. Who was the family member that you were related to at Cheney? Because I wasn't made aware of that.
Yes, it's the young light-skinned girl, Dawn. So she's actually showed me all this stuff. And I'm like, I've never met you. I've never seen pictures of you. You related to me on my father's side of the family. I don't deal with my father's side of the family. And I kept it going this way and she kept it going that way.
McBean, I just need to know the name. Who was it?
As Pearson, I swear on everything, I didn't even want to know her name. Because once she told me she was related to me on my father's side of the family, I kept it going this way, and I told her to keep going that way.
So
she works on Saturdays, light-skinned girl with the glasses. She got a gap tooth just like mine. She works on Saturdays.
All right, thank you.
No, thank you both. All right, so I am going to announce my recommendation. So I have listened to the testimony presented today. I've reviewed all the evidence presented. I do want to put on the record that although this is Mr. McBean's first violation on special parole, he was only out in the community for about 3 months prior to his remand. During that time, he was issued the 3 misconducts for concerning behavior as stated on the record today by his parole officer. So with that, Mr. McBean, Parole and Community Services in the parole violation court did recommend a 6-month a no less than 6-month sanction. So with that, I am going to recommend your parole be revoked and that you serve an approximate 6-month period of confinement as a sanction, and that's with a re-parole date of June 26, 2026. I'm going to recommend the following conditions: behavioral management program for anger management, no contact with victim MS, a general no contact with DC and JQ, a mental health evaluation and treatment as deemed necessary, and we'll do halfway house placement with the Norwich location, and Eddie House Center is the request. However, please know that it's up to Parole and Community Services to place you in a halfway house. I have no control over it. We'll just put the information in, and Officer Pearson is well aware of the conversation today. So that does conclude today's hearing. What happens next is my recommendation is going to go to the board next Thursday on the 16th. On that date, the board can do 3 things. They can lessen my recommendation if they choose to do so. They can adopt it if they choose to do so. And if for any reason they would want to see a longer period of confinement as a sanction, they'll ask you to come back for a 3rd hearing to address their questions and concerns before anything longer is imposed. So that does conclude today's revocation hearing. Any questions at this point?
Am I gonna get any written notification from your office?
Everything. Yep, you'll get the summary from today's hearing. You'll get the dispositions from today's hearing, as well as what happens next week. You'll get it probably the week following in the mail of what the board's final decision was. Okay.
Yeah.
Okay, so this does conclude the revocation hearing for Neville McBean, inmate number 122908. Thank you both. Good luck to you, Mr. McBean.
Yeah.
Thank you, Officer Pearson.
Thank you.
Good morning, Mr. Figueroa, or it's good afternoon. Sorry about that. We're going to get started, okay?
Okay.
All right, so good afternoon. I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning George Figueroa, inmate number 192694. Today is Monday, April 6, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and McDougall Correctional Institution. Can you please state your full name and DOC inmate number for the record?
George Louis Figueroa, 192694.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this afternoon is your attorney. Can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Figueroa.
Thank you. And also present is your charging officer. Can you please identify yourself for the record?
How you doing? Pro Officer Huff, Hartford Special Management Unit.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions for your release. I will review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better weight your evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. A recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Figueroa and Officer Huff, can you both please raise your right hand? You solemnly swear, solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
Yes.
Yes.
Thank you. So we're going to go over the procedure for today. So first I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings, and if I find that you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will then have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
You do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, ma'am.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. You understand these rights, now you're ready to go forward.
Yes.
Perfect. We are now going to review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. Officer, how can you please review the charges for us, starting with number 1, obedience to the law?
Sure. Charge number 1, obedience to the law. You failed to verify your address with the sex offender registry by August 7th, 2025. As a result, you were arrested and charged with violating Connecticut General Statute 54-252, sex offender registry failure to verify address. You were arraigned on November 22nd, 2025 when probable cause was established and a bond was set at $15,000. Charge number 2, problem sexual behavior treatment. Between November 3rd, 2025 and November 11th, 2025, you were patronizing the websites adameve.com, fredericks.com, and others searching for vibrating panties, edgy bondage lingerie, and dirty panties, etc., without permission from your CTPSB therapist or supervising officer. This is in violation of your signed CTPSB treatment agreement. Patronization of any sexually oriented stores, must be recommended by CTPSB staff and approved in advance by my supervising officer.
Thank you. You've also submitted evidence in support of the case. Can you please identify the evidence for us?
Sure. Exhibit A, remand to actual custody order. Exhibit B, parole violation report. Exhibit C, notice of parole violation. Exhibit D, parole and community services signed conditions. Exhibit E, Hartford Police Department arrest warrant. Exhibit F, State of Connecticut Judicial Branch pending case detail. Exhibit G, Center for Treatment of Problem Sexual Behavior Treatment Agreement. Exhibit H, CTPSB discharge letter. Exhibit I, cell phone pictures / search history.
Thank you. You've also submitted the revocation hearing summary, so I'm going to identify those as Exhibit J. You did also file an addendum to the parole violation report. Can you please review the addendum for us?
Sure. Offender Figueroa was in court on February 26, 2026 under docket H14H-CR25-0774313-S. The state was unwilling to pursue prosecution for the charge of violating Connecticut General Statute 54-252, failure to register sexual violence. Therefore, the charge was nollied. Offender Figueroa has no more pending criminal charges at this time.
Thank you. Counsel, to confirm you and your client did receive the notice of parole violation, the parole violation for, and all the other documents for today?
We have, thank you.
And I did receive exhibits from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Exhibit 2, the Hartford Superior Court transcript dated 2/26/2026. Exhibit 3, the letter from Lucia Figueroa. Counsel, do you need time to submit any additional?
We do not, thank you.
And we don't have witnesses today. So at this time, the state will have an opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. So Officer Huff, any comments right now towards the charges?
I'm sure. I just want to mention that this is Figueroa's second parole violation since being released to special parole supervision. His sentence requires him to appear on the sex offender registry for life. Remaining in compliance with the sex offender registry requires him to ensure a valid, up-to-date address is on file and returning verification letters by their due dates. Figueroa was provided with the registry's website several times and encouraged to ensure he was listed as compliant and to follow up with them if that was not the case. He failed to return a verification letter sent to the address on record by August 7, 2025, resulting in a felony warrant being issued for his arrest. When he was remanded, a search of his phone revealed that he was also in violation of a signed CTPSB treatment agreement, as he was patronizing sexually oriented stores online, searching for vibrating panties and dirty panties. It was also discovered that he had pictures of minor-aged children saved in his phone, which only compounds these concerns, as his conviction also included the use of sex toys. As a result of these behaviors, which resemble those of his instant offense, Figueroa was unsuccessfully discharged from CTPSB treatment.
Thank you. Counsel?
Yes, as to charge 1 bail laws, I would argue that there should be a no finding. The charge, as noted, was nollied in court. And as you can see from the transcript submitted by the defense, the state's attorney noted on record at that time that he was the individual who signed the warrant and that it was a mistake, as Mr. Figueroa was in compliance with the registry at that time. That was put on the record. In addition, when the judge was, speaking to my client and he started to tell him, make sure you comply with the registry, the prosecutor, in fact, interjected and said he was compliant and this was a mistake. So I did just want to make the argument for that charge. There should be a no finding. As to charge 2, I would just note, my client's married. He reports this was something that he and his wife were looking at together and were looking into together. But I would very much disagree with the characterization that this in any way mimics the alleged behaviors for his underlying offense. There's nothing in the current violation amounting to that. There's absolutely no allegations here that he had contact with minors or that anything inappropriate occurred. Thank you.
Thank you. Any further statements from either side before I announce my findings?
Real quick, I did read the transcript from the court. They did mention they made a mistake. I also noticed that the address on file was incorrect. However, that is up to Mr. Figueroa to fix. If they have the wrong address on file for him, he's to make a note of that and correct that. That doesn't mean putting this information in your case manager's hands. I believe he told me that his case manager had sent out the original change of address form, which was a combination of the halfway house address and the Reach apartment, their Crystal's apartment he was going to. So I believe that was the mistake. However, that is of Mr. Figueroa's responsibility to follow up with that and not put that in somebody else's hands so that these mistakes can happen. So that's where the behavior is his responsibility to ensure that everything is correct on his end. Also in regards to these sexually oriented stores and patronizing those stores online, his previous violation was involving contact with a minor. So, combining that with looking at these stores, it's very close to his IO, which he was sexually assaulting his niece from the age of, I believe, 9 years old to 13 years old. And that did include the use of sex toys. So I feel like it is very concerning looking at everything as a whole.
I would just say you're speaking of prior violations. There's absolutely no allegation here that my client had any contact with minors. Thank you.
This is the second violation in a year. I just want to make note of that.
Anything further before I announce my findings?
No, thank you.
So on charge number 1, Mr. Figueroa, I'm making a no finding that he violated the condition of obedience to the law based on the argument presented by the defense today, as well as Exhibit 2, where as counsel referenced, that the prosecutor stated that it was a mistake on their end and that you were compliant with the registry at the time. Charge number 2, I'm finding that you did violate the condition of problem sexual behavior treatment based on the evidence presented in states exhibits B, D, G, H, and I. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history. And once the state is concluded, you will have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I would recommend. So, officer, have anything more or anything additional about Mr. Figueroa's background and history at this time?
I'm sure. Figueroa, he was released to special parole supervision to the Watkinson House on January 19, 2024, after serving almost 10 years of his 13-year sentence. He was convicted in 2013 of sexual assault first degree, 2 counts of sexual assault second degree.
Officer, I'm gonna stop you. We all received PBR, so anything additional that was submitted as evidence? Anything?
This is for the record as well, too. I understand that you see it, but everybody else that may be watching this and listening to this, I feel it's important for them to hear as well.
Okay.
I'm sorry, where was I? 3 counts of illegal sexual contact with the victim under 16 years old and possession of child pornography 3rd degree. His charges stem from the ongoing sexual abuse of his niece, which took place from the time she was 9 or 10 years old until she reported the abuse when she was 13 years old. The victim's mother discovered nude photographs of her daughter on his phone, which led to her daughter disclosing that her uncle Figueroa had been sexually assaulting her for years. He was able to groom his minor victim from the time she was young, which eventually led to him showing her pornography when she was 9 or 10 years old and making her do what they're doing in the pornographic movie. Can you give a second, please? The sexual assaults of his niece ranged from digital penetration of her vagina, penetration with sex toys, forced oral sex, and anal sex. These sexual assaults occurred in public places, family residences, and in his vehicle. Offender Figueroa was first remanded to custody for having contact with a minor in January 2024, approximately 1 year after his release to supervision. He served a 3-month sanction for this behavior and was released on April 11, 2024. Just 7 months later, Figueroa was remanded back to custody on a felony arrest for failing to verify his address. I know that was subsequently nollied. In a search of his phone, discovered violation of the CTPSB treatment agreement, which nearly mimicked the behaviors of his instant offense, subsequently resulting in his unsuccessful discharge from treatment. As a result of these continued behaviors, I am recommended that he remain incarcerated for a sanction of at least 6 months to be served consecutive to any sentence imposed by the court. That's all I have for now.
Thank you. Counsel?
Yes, thank you very much. My client's 59 years old, born and raised in Hartford. He does have a very strong support system in the community, including his father, brother, sister, his aunts, uncles, nieces, and his wife, Lucia. All of my client's family do reside in Hartford. His wife does have significant medical concerns, and he was her primary caretaker in the community. He also does receive support from his coworkers, and he does also have 3 adult children. Most recently, upon release to special parole on April 11th, 2025, my client successfully completed Steinhaus. He then was self-sponsored at an address in Hartford through the Chrysalis Center. For the past 2 years, my client was working full-time for his dad's business, George's Tire Service, out of Hartford. He recently reported treatment at CTPSB, which we do see he was participating in addition to outpatient services at CRT. He does have a significant medical history, including high blood pressure and prediabetes, which he does use medication for. He has been able to meet with a medical provider more recently due to issues regarding his kidneys. He is currently successfully registered on Connecticut's registry. He was on a medium contact schedule. He reports medication compliance since being remanded. He has never had any DRs during any period of incarceration. So he is, I would argue, a model inmate. Upon reinstatement of special parole supervision, my client would like to be sponsored by his wife at the address provided. As a backup, he would request a halfway house in the Hartford jurisdiction. He is able to return to his father's business and is open to any sort of treatment recommended, including successfully completing the CTPSB program and reestablishing services through CRT. I'm asking that you consider releasing my client on the next available board review date. He was doing pretty well, I would argue, well on supervision. He was compliant with his legal obligations and his treatment requirements while in the community. He has now been incarcerated for about 5 months. And I would argue that that is more than a sufficient sanction for the allegations. Thank you.
Anything additional from either side before I announce my recommendation?
No, ma'am.
Take a moment. So I have listened to the testimony provided today. I've also reviewed all the evidence submitted. With that, Mr. Figueroa, I am going to recommend your parole be revoked and you serve an approximate 5-month period of confinement as a sanction. That's with the reparole date of April 20th, 2026. I'm going to recommend the following conditions: no contact with your victim's DM, enhanced internet and device monitoring, no contact with minors, problem sexual behavior treatment, restriction on pornography, and I will not do the halfway house because you have a sponsor unless Officer Huff. Not sure.
I would put the halfway house on there, please, because as much as I would like him to go home to live with his wife, there are some barriers there that prevent other potential issues anyways at this
All right,
time.
so then I will do the halfway house placement as a backup in case if they need it. What was the location?
He was at
Hartford?
Crystal's before, so he wasn't self-sponsoring either, so that's,
Okay. Sorry, Hartford is the location?
Yes, it was in Hartford. I think the address should be on our report.
So that's my recommendation, Mr. Figueroa. What happens next? I also want to make some notes on the record too. This is your second violation on treatment. I'm doing this backwards, sorry. You were only out on supervision for 7.5 months. So I do just want to note that on the record. That was already stated previously by both sides. So what happens next, Mr. Figueroa, is that my recommendation is going to go to the board on April 16th. On that date, the board can do three things. They can lessen my recommendation if they choose to do so, any date between the 16th and the 20th. They can adopt my recommendation if they choose to do so. And then if for any reason they want to see a longer period of confinement as a sanction, they'll ask you to come back for another hearing to address their questions and concerns before anything longer is imposed. Okay, so that does conclude today's hearing. Do you have any questions?
No.
So that concludes the revocation hearing for George Figueroa, inmate number 192694. All right, good luck to you, Mr. Figueroa. Thank you, Officer Huff. Thank you, Attorney Dean.
Thank you.
Have a good one.
Thank you.